Welcome to a Law Shelf case study presentation, where today we will be discussing the case of ITT Engineered Valves versus United Steel. This is a recent case from the Eastern District of Pennsylvania, where we will be discussing when an arbitration award can be vacated and the application of a public policy exception to the vacation of an arbitration award. Let's begin. To start with this case, you need to understand a little bit about the process of a collective bargaining agreement. In this case, United Steel is the union. It is the United Steel, Paper and Forestry, Rubber, Manufacturing, Energy, Allied Industrial and Service Workers International Union. We will call it the union today. They represented many employees at an ITT facility in Pennsylvania. And through the collective bargaining agreement process, the management and the union go back and forth and specifically negotiate several provisions of the contract. And in this negotiation, they contain an arbitration clause. It's a negotiated for provision. Its arbitration clauses are very common in collective bargaining agreements, and it's a way for parties to resolve their disputes. In this arbitration clause stated that questions of interpretation, application, or claimed breaches of this agreement not resolved through the grievance procedure could be appealed for resolution by an arbitrator. In essence, this clause states that if a party is unhappy with something that happens at work, they first go through the grievance procedure with the union, and if the grievance procedure does not satisfy their issues, they then appeal that through the arbitration process. In addition, this collective bargaining agreement stated that ITT, the company, may, quote, promulgate and enforce reasonable plant rules and regulations, unquote, and suspend or discharge for cause. This provision allows the company to create their own rules and their own standards for when an employee can be fired. It allows the company it doesn't lay out the specifics within the contract, but it allows the company to create their own rules. With that background and understanding that the parties in this case are subject to this collective bargaining agreement, we'll take a look at the facts of this case. We have employee Wood, who was employed as a technician at the facility. Wood gets into a fight with his manager, Byla, over enforcement of ITT's face mask requirement during the pandemic. This was June of 2020. The pandemic was relatively new, and they had a face mask policy in place at the facility. So Byla, who was a supervisor, sees Wood speaking with another party. And the other party's face mask was below their chin. And Byla, as supervisor, walks over to them and says, "Excuse me, can you please raise your face mask and wear it properly, covering your mouth and nose?" Wood responds saying, "I was in the military. I am comfortable speaking to this man with his face mask down." To which Byla responds, "We are grateful for your service, but in order to be in compliance with the current COVID-19 policies, I need you to put your face mask back on." Wood says, okay. He goes back to his office, he sits down, and he writes an expletive on his mask. Byla was from Sri Lanka, and Wood writes F Sri Lanka on his face mask. He proceeds to put this face mask back correctly onto his face. Byla at this point left the floor of the plant, but another supervisor sees Wood wearing this inappropriate mask and calls Wood into his office. When speaking, the supervisor says, "This mask is inappropriate. What can I do to fix this situation between you and Byla?" And Wood responds, "How about a one-on-one meeting with no consequences?" with Byla, which the other supervisor perceives as a threat against Byla. Wood gets suspended and ultimately fired. He gets fired under one of the rules that ITT had promulgated, stating that, quote, immoral or indecent conduct, unquote, in violation of ITT's harassment, discrimination, and retaliation prevention policy. They say your behavior, the wearing of this inappropriate mask, and the threatening of a supervisor is immoral or indecent conduct, and he gets fired. As allowed through the collective bargaining procedure, the union pursues arbitration to challenge Wood's firing. And the parties go through arbitration. The arbitrator reviews this whole circumstance, takes a look at all of the information, and makes a few determinations. The arbitrator, first and foremost, reverses Wood's termination, says the termination was improper. It says that ITT's policy actually outlines two different standards. It outlines a major act of poor behavior, which is subject to suspension, and an intolerable act, which calls for termination. And we will get into more specifics about what constitutes a major act. First, what constitutes an intolerable act. In this context, the arbitrator finds that threatening, intimidating, or interfering with rights or using abusive language, the comment that he wrote on his mask, was only a major act. It was not intolerable. It was merely offensive, and therefore he should not have been terminated as an intolerable act. He should have been suspended from a major act. In addition, the arbitrator makes a few additional notes. He says Wood feels that his military service had been belittled by Byla. He said he was very angry because after their conversation, he felt that he had really been belittled and he'd served the country, and that's why he was so angry. In addition, he says the mask with the curse directed at Sri Lanka was not worn very long. He only wore it for about 15 minutes when another supervisor told him to take it on. And Byla himself never actually saw Wood wearing this offensive mask, so that Byla didn't actually see the offensive comment. Byla never lodged a harassment complaint against Wood, and Byla even testified in this arbitration that he did not feel personally harassed as a result of the incident. He heard about the mask, but at the time, he didn't really feel harassed because he hadn't actually seen it. Wood testified that he apologized to Byla and that he didn't actually mean his comment as a real threat, that he spoke to his supervisor, I'd like a one-on-one, but he didn't really intend that as a threat to Byla, and that it shouldn't be taken that way. The arbitrator says, yes, this behavior was very inappropriate and unprofessional and improper, but it does not rise to the level of intolerable or immoral or discriminatory harassment. The arbitrator says this was not great and he should be suspended, but this is not the kind of behavior that we think constitutes, or that the arbitrator thinks constitutes, immoral conduct worthy of termination. In order to support his conclusion, the arbitrator makes some additional findings. The arbitrator takes a look at two previous employees that ITT had managed for similar behaviors. They had displayed similar conduct, and neither of those employees had been fired. The first employee had drawn an offensive picture of somebody with wounds, indicating he was going to harm someone on his work apron. This employee was reprimanded and suspended, but that suspension was eventually even turned into a written warning. So for a similar act of drawing something offensive on an item of clothing at work, this party was only given a written warning, while Wood was terminated. A second employee had called a coworker a racial slur and was charged with a major act, not an intolerable act. This employee was not their first offense. They had another major act violation in the past. And because it was the second offense, the party was actually fired. Under the rules and regulations, it states that your first major act violation will result in a suspension, and a second major act violation will result in termination. This is different from an intolerable act where one violation is enough to result in a termination if it rises to the level of an intolerable act. Due to the disparate treatment and the lack of seriousness in Wood's actions, according to the arbitrator's interpretation, the arbitrator reversed this finding. Instead, he said that Wood's behavior was sufficient, should cause a 1-week suspension without pay, and that would be sufficient punishment, that the termination was not warranted, and instead, in light of how these other employees were treated, Wood should be given a 1-week suspension. ITT was not happy with this decision, and they decide to attempt to vacate the arbitration award. The way that arbitration awards can be appealed is we go through a vacator process where we try to say, I think this award should be vacated for one reason. So they file a lawsuit, and the lawsuit tries to vacate the award on several grounds. The two main grounds, they say, is that it contravenes public policy related to workplace conduct. They say there are a couple public policies in place when it comes to how employees should be treated. And this arbitration award violates those public policies. The first public policy is against racial or national origin harassment and discrimination. We have a public policy, we have rules such as Title VII that prevent discrimination in the workplace, and this award by the arbitrator contravenes that public policy. Additionally, there is public policy against threats of workplace violence. It is in good policy. We should do everything we can to prevent workplace violence or threats of workplace violence. And his arbitrator's award does not support that public policy. Those are some of the main arguments that ITT makes. And then they have several additional arguments in order to vacate this arbitrator's award. Number one, they say the language in federal and state civil rights laws indicates a strong public policy in preventing discriminatory behavior. OSHA, as well, the Occupational Safety and Health Administration, contains language that prohibits terroristic threats, that these terms could be considered terroristic threats when they're against somebody for their national origin. In appellate court precedent, they find a court that also says that an arbitrator cannot return an employee to work unless there is a termination on the merits that the employee did not engage in harassment. We will get into more detail of what that means, but essentially this argument says that if Wood engaged in harassing behavior, if Wood harassed Byla, the arbitrator cannot send him back to work unless we have made that official determination. If there really was harassment or if there wasn't harassment, as long as it's alleged, the arbitrator has to make an official determination on whether harassment existed before he can send the employee back to work. Lastly, ITT claims that the arbitrator's findings of fact were flawed. When the arbitrator made this decision, he made several findings of fact. For instance, he determined whether or not what happened in this altercation. Did Wood apologize to Byla? Did Byla make a comment about his military service? The arbitrator made these findings of fact, and the ITT argues the arbitrator did that poorly. Their fact finding was flawed and needs to be reviewed. During this lawsuit, the union has a response. And they argue against each and every one of these points that ITT makes. The union argues that the issue isn't whether there's a public policy in preventing Wood from engaging in the behavior that they did, but whether reinstating him would run contrary to an explicit, well-defined, and dominant public policy. That when we're talking about this public policy exception to vacating an arbitration award, it's a very specific two-step process. One, we have to identify whether there is a dominant public policy, and two, whether this behavior ran contrary to that public policy. The union also points out that the appellate courts had refused to overrule arbitrators' reinstatement of employees, even when they had committed acts more serious than Wood had. So specifically, they say that this threat, such as it were, had been reasonably found by the arbitrator to not have been a threat at all. That the arbitrator concluded that it wasn't even a threat. It wasn't said to his face. He didn't intend it to be a threat. He apologized for it. And that this threat is not serious enough to warrant termination. Additionally, it did not create a hostile environment because Byla had not testified to the perception of an abusive environment. That in order to have a hostile work environment, the victim needs to feel it. The victim needs to feel the subject of a hostile work environment. That the victim's working conditions need to be changed and feel afraid or discriminated against. And that since Byla never actually saw the offensive acts and never actually heard the supposed threat, this really was not a hostile environment for him because Byla had just gone about his day not knowing about all these offensive behaviors by Wood. The union says that nothing in ITT's policies requires firing for isolated incidents of harassment or even racist speech. They say that things that rise to the level of a major act, the first major act, merely calls for suspension under ITT's own rules. And that nothing in their handbook says that the first act of harassment is going to lead to termination. Therefore, the union believes that the week-long suspension is an adequate remedial action in any case. And that was the proper standard. They believe that the arbitrator was correct, the week-long suspension was sufficient, and the arbitrator's ruling should not be vacated. An important element to understanding how this case results is understanding the standard by which an arbitration award can be reviewed. Under the Federal Arbitration Act, which is an act that tries to uniform how arbitrations are handled, there is a very strong presumption in favor of enforcing arbitration awards. What that means is that an arbitrator is given fairly wide latitude in making their determinations. And once those determinations are made, they are very likely to stick. Overturning an arbitration award is not the same as going through the appeals process if you're going in a regular trial court. It's the grounds through which you can vacate an arbitration are very different. An award is only vacated only exceedingly narrow circumstances. So the standard when this court comes upon this arbitration award and they have an employer saying, we would like this award to be vacated, they are going to look very carefully and give very significant deference to the arbitrator's decision before they determine that it's something that should be overturned. So the court says that the fact that it disagrees with the arbitrator is irrelevant as long as the arbitrator is even arguably construing or applying the contract and acting within the scope of his authority, that a court is convinced he committed serious error does not suffice to overturn his decision. The court says, look, if we were to evaluate this situation independently and we were to say, we disagree, we think this behavior was immoral and offensive, and we think Wood should have been terminated. Even if we think that, we're only going to overturn the arbitration award if there's no possible reason that the arbitrator decided the way that he did. So the fact that we might disagree isn't the point. The question is there any basis for the arbitrator having decided the way that he did? And if so, we need to leave that award in place. We have to find that the arbitrator manifestly disregarded the law. That's a common reason for why arbitration awards are vacated. Often, if an arbitration award is vacated, it's because there's some sort of partiality or bias on the arbitrator. So if you were to find out after an arbitration award that the arbitrator is actually, the brother of one of the plaintiffs, or had a secret meeting with one of the plaintiffs, or there's some sort of bias or partiality, that might be a reason to vacate the arbitration award. Or if the arbitrator manifestly disregarded the law. If the arbitrator said, oh, sure, I know about that law, but I don't like it, so I'm not going to apply it. Otherwise, the arbitration award is very likely to stick. So the public policy reasons set forth by ITT requires that we have A, a well-defined and dominant public policy, and B, that this award violated that public policy. And that's the grounds under which ITT is attempting to have this award vacated. But we're going to look very closely before we decide to vacate it. So the first question that ITT poses is this public policy against threats of violence in the workplace. The threat of the arbitrator's reaction. The threat, that alleged threat, was Wood's statement that the situation could be resolved with a, quote unquote, one-on-one meeting with Byla with no consequences. And the arbitrator said, quote, truthfully, I do not view this response to a supervisor's question as a threat towards Byla. To me, the threat would be talking directly to or writing directly to Byla and telling him, I will kill you or I will beat you the next time I see you on the IT premises. Those are true threats, quite unlike responding to a supervisor's question of what Wood would like to see. And so the arbitrator really says, I don't see this response as a threat. Wood was sitting in a private office with a different supervisor and said, here's what I'd like. I'd like a one-on-one meeting with him. That's not the threat. The arbitrator says, if he'd gone to Byla and said, I'm going to kill you, or watch out next time, that might rise to the level of the threat. But the arbitrator didn't find that here. And remember, the question isn't necessarily whether the arbitrator's right, but whether there's any rational basis for the arbitrator's decision. So if this is logical, if we can see where the arbitrator's coming from, even if we disagree, as long as we can see, the arbitrator's award is going to stand. And the court observes that there was sufficient support for the determination that this should not be considered a threat. The court said there's other support, there's other reasons why we think the arbitrator said, you're right, this isn't a threat. For one, Wood testified that he didn't mean it as a threat. Now, whether that's reliable testimony, at least he did testify that he didn't mean that way. He didn't even make the comment to Byla himself. So, and the comment is relatively ambiguous. It doesn't reference violence. There's no threat of weapons. There's no actual violence. A one-on-one. He claims I could have been meeting a one-on-one conversation. There's no outward violence involved in that language. Moreover, the arbitrator says that even if it determined that the arbitrator's conclusion regarding the threat was incorrect, improvident, or so unfounded as to be silly, even if we said, oh my gosh, how could you, arbitrator, ever possibly find that this was not a threat? Of course it was a threat, and you'd be silly to find otherwise. Even if we believe that, we still couldn't vacate the award on this basis. Vacating the award on the basis of the arbitrator's factual determinations requires that there be absolutely no support at all justifying those determinations. And the court here says we can't say that. We can't say that we find no support whatsoever for the arbitrator's decision. The fact that the comment wasn't made towards Byla, the fact that it was somewhat ambiguous, we understand where the arbitrator's coming from. There is sufficient support to allow this arbitrator's decision to stand, especially since that's the decision that he made at the moment. With that understanding of the standard for vacating the arbitration's award in mind, the court applies the public policy in terms of requiring discharge. And the court says that even if there was a threat of violence in this case, reinstatement of Wood would not necessarily contravene public policy against the threat of violence in the workplace. The court observed that there may be a public valency against threats. We're not doubting that. We understand that there is some public policy that says we shouldn't have threats of violence in the workplace. That is something to strive for. We do want a workplace free of violence or free of threats. But the way to get that is not necessarily by terminating any employee who may be inclined to make a threat. That if there is, we can't just say, okay, it's a zero policy, right? That the only way to ensure that there's no threats or no violence is fire everybody who has made any inclination or any notion of a threat. The court says we should really look at this employee and see if this employee is what the quote calls amenable to discipline. What about helping this employee improve? What about disciplining this employee? Perhaps suspending them or giving warnings or encourage programs that might indicate how to resolve your behavior, helping this person in a different way, perhaps giving them another outlet for their threats of violence. What other way there might be, the court says we're not ready to say that the only way to serve the public policy of having no threats of violence in the office is through termination. So the arbitrator in this case determined that Wood had a clean history. He hadn't suffered from major acts before. He'd been at the company for a while and had never had any problems. This was one specific incident at a stressful moment in time. He thought his military service had been disrespected and that he needs to be disciplined for sure. But the court found that the arbitrator determined that Wood was amenable to discipline and that he could be disciplined in some way that was less than termination. The arbitrator specifically found that 1 week of suspension was enough, and the court tended to agree. The factual determination and the fact that a suspension was imposed was enough to constitute a reasonable decision by the arbitrator. All of these facts together make us think the arbitrator's decision was reasonable enough to be upheld. Again, even if the court might have found differently, that's not really the question. The question is there any rational basis for the arbitrator's decision? and the court finds that yes, there is, all of these aspects put together show whether there actually was a threat, whether that threat violated public policy, whether the only way to handle it was termination. All of those elements put together led to the arbitrator to conclude the way he did, and that was a reasonable conclusion. With that, the court goes to discuss the next public policy exception, the policy against discrimination and harassment. So there's also a discrimination claim, a discrimination element to this case. ITT points to a Third Circuit Court of Appeals decision. And that decision was a decision over a sexual harassment case, not a racial harassment case, but over a sexual harassment case that says an award that fully reinstates an employee accused of sexual harassment without a determination that the harassment did not occur violates public policy. Essentially, what this decision said was that if somebody is accused of sexual harassment and the court has to make an actual determination, did that person commit sexual harassment? Until that determination has been made, the person should not be reinstated. Because we need to know, for the safety of the victim or the alleged victim, we need to know how comfortable that person is going to be and whether it's safe to put that person back into the employer's environment. So the court says we have to first make an explicit determination of whether or not harassment occurred before we can fully reinstate the employee. In that case, it reversed an award that would, quote unquote, allow a person who may have committed sexual harassment to continue in the workplace without a determination of whether sexual harassment had occurred. ITT takes this Third Circuit appeals case and says that's applicable to the case here. ITT contends that to reverse the firing, to reinstate Wood after his week suspension, the arbitrator would have had to make a determination that no discrimination or harassment occurred in this case. Now we need the arbitrator to say whether or not Wood's behavior constitutes harassment or constitutes discrimination before he can be reinstated. The ITT says the arbitrator did not make this determination. The arbitrator didn't address this harassment claim, and so without that, we need to make sure that we specifically look at the claim of harassment and make a determination before he can be reinstated. The court says, okay, we will look at the arbitrator's decision and see what the arbitrator said. The court says, here's what the arbitrator did find. And the arbitrator said, while Wood's actions were totally improper, the court readily acknowledges that this was not acceptable behavior. Nobody is saying, oh, it's no big deal. Clearly, this behavior was improper. The arbitrator says, while Wood's actions were totally improper, quote, Bila did testify that he did not feel personally harassed and did not see the writing on the mask. His concern was that Wood was creating a hostile environment, so I don't see harassment of Bila as definitive. He says Bila was concerned that having this offensive language on a mask, even though Bila didn't see it himself, it could be offensive to any other employee in the workplace, whether they're Sri Lankan or not, particularly if they are, they could be offended by this. This could have created a hostile work environment. However, Bila himself wasn't actually harassed by it or discriminated by it. In fact, Bila never even actually saw the offensive language. The arbitrator continues, also, the union pointed out that proof of harassment is a double-edged sword. The conduct toward Bila must be based on a characteristic that is protected by anti-discrimination law, and the behavior must negatively affect Bila's working conditions or his terms of employment. They say that in the ITT is arguing we must specifically look at a claim of harassment. In order to make a claim of harassment, we have to show a few things, including that the victim's working conditions were disrupted. That when an employee makes a claim of harassment, they're saying, I feel so uncomfortable at work that I can't work under these conditions. My ability to work, the terms and conditions of my employment have been changed, have been altered by somebody else's behavior, somebody else's harassing or bullying or discriminatory behavior. The court says this first condition may have been met. The second condition was not. Bila's working conditions were not altered. It didn't affect him in that he didn't see it. So if you need us to come up with a distinct conclusion about whether harassment happened, it is unlikely that Bila was harassed. So the arbitrator makes this factual finding that Wood did not engage in quote unquote discrimination under the law. So they go on to say this is a really important element of what the arbitrator said. The arbitrator did do a pretty concrete analysis of whether or not Wood engaged in discrimination. Additionally, the court says we have to look at that Third Circuit court case to begin with. For starters, we don't think that that case is actually applicable here. The circumstances and facts of that case were very different. That case concerned a sexual harassment case, not a racial discrimination case, and the whole circumstance was very different. They say in the context of that Third Circuit case, we were talking about a sexual harasser who had allegedly harassed a woman and inappropriately touched her. And the question was, is it safe to put that man back into an office with his alleged victim before we even determined if he did commit harassment? And those facts and those circumstances are really different from the situation on the floor of the plant at ITT Engineered. So the court here says we don't conclude that that Third Circuit court case is applicable in the first place. Even if it was applicable, the arbitrator's decision is entitled to deference, whether it is a determination of law or a determination of facts or a mixed determination. So even if we did think that Third Circuit case is applicable, which we don't, then we think the arbitrator's decision was appropriate enough. It was a fair enough determination of law or fact. In any case, the court said that the arbitrator's determination that Wood's action did not rise to the level of discrimination was reasonable in light of the underlying record. If the arbitrator here found that this was just a major act and not an intolerable act, that is a fair conclusion, and we don't think it's necessary to say the arbitrator is completely wrong and this should have been deemed an intolerable act, where termination would have been more appropriate. Therefore, there is no public policy that requires Wood's termination. The grounds that the public policy of threat of violence are insufficient, the grounds of public policy on threat of discrimination were insufficient, and therefore there's no policy that we find this arbitrator's award so violated at public policy that it should be overturned. The court says we just don't see that here. In that case, the court goes on to take a look at some of the other claims that ITT made. The court looks at ITT's element regarding the discharge requirement for determination. So ITT here is saying that any finding of discrimination requires discharge for the employee. The court says, we want to take a look at that. And do we think that if we did find discrimination, it's necessary that the party be discharged? And the court says, as our previous analysis, even if the Wood's behavior constituted discrimination or harassment, the public policy associated with preventing discrimination does not require termination of every employee who engages that behavior. It only requires that behavior not go unpunished. So our rules don't say any person who commits this behavior must be terminated. They say the person must be punished in some regards. That Third Circuit language that ITT was talking about before, that Third Circuit case, they use language criticizing an award that fully reinstates the person that committed the harassment. So in this case, Wood didn't go unpunished. He was suspended with a major acts violation and now reinstated. Not to mention that major acts violation now goes on his record. So with that, if he commits a second of major act offense, that would be grounds for termination. So between those two standards, once you have one on your record, now any major act is going to be a second issue, which does become more problematic. It indicates that perhaps this person is not amenable to discipline, that these issues have not been resolved. So that will go on his record, but there's still just a major act for this one decision. So in conclusion, the court says, ITT, we understand the desire to keep your workplace free of threats of violence and free of discriminatory conduct and free of harassing conduct. That is absolutely a public policy that we would like to uphold, and we understand why you would like a workplace that's free from those concerns. However, your disagreement with the findings and conclusions reached by the arbitrator are not a sufficient basis to warrant vacatur of the arbitration award. That's our deference to arbitration awards, and that's not just in this case. In arbitrations everywhere, they are given substantial deference. And so we cannot say that your public policy concerns are strong enough to overrule that substantial deference that we're going to give to this arbitrator's decision. Under the circumstances, the court lacks the authority to overturn the arbitration award, which directs reinstatement of Wood after a 1-week suspension. So we are going to find that this arbitration award will stand, and 1-week suspension is sufficient punishment for the behavior that we saw here. Thank you so much for listening to this Law Shelf case study. We hope to see you back soon.